am very pleased to be joined with Scott today. He is Nixon Peabody's co-chair of their litigation department. He has a very great expertise in class action and aggregate litigation, and we thought it'd be very interesting to look at how class actions are being dealt with, particularly with regards to settlement in Canada and the United States. When we have cross-border litigation in class actions, the settlement process often goes hand in hand, and often, well, in fact, almost inevitably, leads to the same result, a settlement in both countries. The Pella case is interesting because it had a situation where there was initially a settlement in both countries, and then the situation went somewhat awry. The allegations in the Pella case are quite simple. Pella was a manufacturer of windows. The windows were put into houses. An allegation arose that there was water penetration into the windows causing rot. And there was also an allegation that Pella was aware of these defects and had organized its warranties to work itself away around those defects. In the United States, the litigation lasted for about 6 years prior to the settlement. It was certified. And ultimately went to settlement in both Canada and the U.S. and was approved in both Canada and the U.S. at the initial court decisions. The U.S. decision was appealed, and it came before Judge Posner. Judge Posner rejected the settlement in one of the most harsh and entertaining decisions that you could read. And I really, just to put the headlines from a variety of legal commentators like Forbes, which called it, Pella class action settlement is so bad, court tosses lawyer and his father-in-law, the lead plaintiff. Posner savages scandalous settlement in the Pella case. Posner tosses scandalous settlement, says judge didn't heed the warning signs. So that is what happened in the United States. What happened in Canada? Settled. And that, of course, led to the big question is, why? Why did we see this scandalous decision in the United States and settlement in Canada? And what does it tell us about the state of play in class actions in both countries? Now, settlement approval in Canada is very similar to that in the United States. It has to be, in a class action, it has to be approved by a judge. The terms have to be brought before the court and explained to the court. There has to be an affidavit explaining the settlement, the pros and cons of litigation, the litigation risk, the benefits to the class. It has to be noticed to the class. There's an opportunity for objectors. And as in the United States, they're typically approved. And these settlements had a lot of similarities. There was compensation to the named plaintiffs. The maximum damage award per structure was precisely the same. The maximum damage award for windows was the same. There was coupons as part of the settlements in both countries. Warranties were extended in both countries. There was the length and the complexity of the notice were the same. There are lengthy claim forms, which Judge Posner took a lot of objection to, but they were the exact same forms in both countries. Significant information was required by the class members. The claim could be rejected if it was not filed, the forms were not filled out and filed completely, and any reduction in the legal fees reverted to Pella in both Canada and the United States. And so there's all of these similarities between the two settlements. So the real question is, what are the key differences? And one of the key points, and particularly Posner looked at this, was what was the value of the settlement? In the United States, the plaintiffs estimated the settlement value was $90 million. The defendant estimated it was somewhere between $8.5 million and $22.5 million. Judge Posner thought that 8.5 was by far and away the most likely, and that was even probably generous. In Canada, there was no estimate of the settlement that was given. And in the United States, the legal fees were $11 million, and in Canada, there were $600,000. Now, Canada, US, 10-to-1 ratio in population. That's 6.5 million to 650,000. 11 million is not all that far off. It is twice as much, but God knows, we all know American lawyers make a lot more than Canadian lawyers. However, the American legal fees had no rational relationship to the actual value provided to the class in the settlement or to the actual time that the counsel had put into the case. Whereas in Canada, they had produced the dockets and explained to the court the amount of time that they'd put in, and explained the multiplier was a 2.2 multiplier. So they were getting 2.2 times their legal rate for the settlement, saying that that was warranted given the risk involved, and the judge in Canada agreed. There are other differences. For example, the representative plaintiff in Canada was independent. In the United States, it was the father-in-law of the plaintiff's counsel. Plaintiff's counsel's wife was also a lawyer in that law firm, and Judge Posner thought that that was quite improper. There's also, in Canada, no objectors, and in the United States, the class had originally had 5 representative plaintiffs. 4 of them objected to the settlement. The father-in-law did not. Plaintiff's counsel replaced the 4 objecting plaintiffs with new representative plaintiffs who, of course, agreed with the settlement. But the objectors were brought by the 4 original representative plaintiffs, saying that they objected to the settlement. And Posner said that that was an incredibly bright warning light that the court ought to have followed. In Canada, there was one objector, but that objector had objected on individual reasons as opposed to any class-based reasons, and the judge said that there really was no objection. Now, Posner also commented on the take-up rate in the United States, and while typically you wouldn't have this as part of a settlement agreement, because it was on appeal, they did have the information on the take-up rate. Of the 225,000 notices that had been provided to the class members, 1,276 claims had been made for a take-up rate of 0.0057%, which Judge Posner said was remarkably low and had led to actual claims made, and not paid, but made, of less than $1.5 million. So the question then becomes, what does this tell us about Canada and the US? And first off, Canada does typically have a lower certification threshold, and we typically have less scrutiny of class action settlements. In the United States, we've seen class action reform, and we think that this may lead to some foreign shopping. One of the things that has become quite interesting is we see a migration of plaintiffs' counsel from the United States to Canada, both in putting together strategic partnerships, but also and actually physically moving. We've had American lawyers moving into the Ontario market, living there and practicing law there, seeing opportunities in class actions that are available there. We also think there's also a potential for larger classes in Canada, because there are going to be people who think that if they can get a settlement in the class action in Canada that will be enforceable, that it becomes an attractive jurisdiction for people to come to. Finally, my point on this would be that I don't think Canadian class actions have matured to the point of the United States. We still have a judiciary that by and large believes that class counsel will act in the best interests of the class and will do so in a selfless manner. I will contrast that to the comments that Judge Posner made as follows. Class actions are the brainchild of lawyers who specialize in prosecuting such actions and in picking class representatives, and they have no incentive to select persons capable or desirous of monitoring lawyers' conduct of the litigation. Class counsel, ungoverned as a practical matter by either the named plaintiffs or by other members of the class, have an opportunity to maximize their attorney fees at the expense of the class. And I can say, sadly, in Canada right now, the only people who believe that are defense counsel, and we are so jealous of Judge Posner. Scott, I'd appreciate your thoughts on this.
Well, it is a fascinating comparison, and I think a lot of the roots of the differences are taken from the fact that the class action device in the States is much older, much more developed. The same type of results that happen in Canada with Pella are historically known, and only because of CAFA 10 years ago and a very active change to the legal landscape by our Supreme Court have reforms been instituted and tools really given to the defense bar to make sure that the tool is not misused and abused and only becomes a way in which plaintiffs can get a significant payday at the expense of classes who get nothing. So against that, you've got this additional overlay which comes through in Posner's opinion that at some point there's this magic moment when the plaintiffs and the defendants agree that they want to settle this. And let's face it, everyone out there who's managing a class action knows it's high risk. The costs of prosecuting a thing or defending successfully is very expensive, and you want to liquidate it, and you want your lawyers to get the best job possible. But the lesson from Posner is, if it sounds too good to be true, it may be too good to be true. And you've got to be careful that it doesn't get blown up, simply because you've got now a complete absence of the adversarial process. You know, we work in courts battling each other back and forth, and the judge sits as the referee to make judgments, sometimes calling balls and strikes, sometimes handing it over to a jury for that. But when you get to the settlement moment, that adversarial relationship completely dissipates. And then it's left to objectors or the judge, him or herself, to superintend the fairness. And so here, I mean, there were all kinds of circumstances that should have given both plaintiffs and defendants some concern. You've got collusion opportunity between the plaintiff and the lead plaintiff. You've got 5 original representatives, lead plaintiffs, who get removed by the plaintiff's counsel because they're not happy with the way that the lead lawyer is handling the case. I love that quaint little belief in Canada that the plaintiff's lawyers work in the best interest of the class. That's so cute. It's really, you're better people than we are, I know that.
Well, we do have sweet dispositions, but I think you make an excellent point in that from a defense counsel viewpoint, this in fact is a nightmare because they've gone through 6 years of litigation. They get to the point where they get a settlement. Settlement's approved. The settlement's going forward. Objectors appeal that settlement. And 6 years later, they're told, now we're going to have a brand new lawyer for the plaintiff class. Now you're going to go back to square one. Now you're going to have to go and work with this brand new lawyer and work all the way through. All of the money, all of the time that you've put into it so far is wasted, and you have to start at ground zero again, which to me is a huge incentive for defendants to keep this in mind and to figure out a way to ensure that the settlement will be approved. Because if the warning signs are there for Judge Posner, surely they're there for the defense counsel at the time. Now, one of the interesting things about this is that there was a day-long hearing at the lower court level on the settlement. It wasn't something that was presented and they had a very brief discussion and it was approved. There was a day-long evidence put before the trial, the original court, and the original court ruled, listening to all of those things, that even in those circumstances, the settlement was appropriate. But Judge Posner saw it differently. And I think that this is a case where we as defense counsel have to be very sure that the settlement we're going forward with is one that we can defend, and we can defend with a straight face and honorably to ensure that it gets accepted.
And so there comes the tension. The practice pointer that will require some development is you're the defense lawyer and you've got to work with your client and you're bringing the unhappy news. No, don't go with that really good settlement out there. We have to make it more lucrative. I mean, that's an unsettling conversation, but that's the implication of something like this. You need someone who's maybe not even part of your legal team to look at this as a judge would and make a determination of, are there earmarks of collusion or problems from the objector's standpoint, or lack of adversarial development of a settlement that might make it tossed. And I think when you have a really great settlement coming together, getting some independent eyes to look at this to make sure you don't set yourself up for that kind of risk on appeal and all of the years of legal fees wasted only start again might be a prudent way to go. But I don't relish the day when I have to sit with a client and say, we have to think about making this a better settlement for the plaintiffs because we're not sure it's going to fly.
And I think there's other warning signs that you have to take a look at. Here, there was no independence of the representative plaintiff, and in those circumstances as defense counsel, you're going to have to go to your client and say, look, I'm not sure in the circumstances we can go forward and approve a settlement here. We may have to continue to litigate this or bring the situation to the court's attention and get a ruling from the judge as to whether or not there's sufficient independence here for the class representative to fulfill his fiduciary duties to the class and in the approval process of this settlement.
The other piece that gets kind of interesting, and you mentioned it in your slide, Jim, that there's going to be some forum shopping. So a lot of what happens here is going to be the luck of the draw. I mean, maybe you can get a settlement by a trial judge that does the full evidentiary hearing and makes findings that are favorable, and you take your chances on appeal in the circuit and see if you've got a chance to make it fly. But it starts to feel like high-risk poker because all the chips are on the line. If you're right, great, you got a terrific settlement. You don't have to do enhanced compensation for the class. You've liquidated your risk. You move on to your next battle. But if it turns out that it has these earmarks of unfairness, and the judge maybe makes good findings for you, but the appellate court says no, boy, are you in a world of hurt.
Which means maybe you should be coming to Canada to see if you can get your settlement approved.
So is that what's happening? Are you seeing an influx of American lawyers to Canada?
There is not a flood yet, but there certainly is a trickle of American lawyers coming to Canada. We are seeing a tremendous amount of coordination between American counsel and Canadian counsel. I don't think there are any formal relationships yet, but there are certainly very strong informal relationships. We are often the tail that gets wagged by the dog for class actions. Occasionally we get to be the dog, but usually we're the tail, which means that we often see a case that is, like Pella, brought to the Canadian jurisdiction in almost a final form. For example, in the United States, Pella was a contested certification and went through 6 years of litigation. In Canada, it was a consent certification as part of the settlement process. So a much more streamlined process in Canada than in the United States. Alternatively, I'm working on the Microsoft trial in Canada right now. We're heading off to trial, and I think we will be the only jurisdiction in the world that ever went to trial on the antitrust Microsoft case.
So what's the landscape look like for appellate review? What's different in the States is for the past 6 terms anyway, and really for a decade, our Supreme Court has been very active, taking on issues like arbitration clauses that waive class status, looking at numerosity and typicality and adequacy, and really giving the defense meaningful ways to challenge these things and beat back what had been a rubber stamp certification of class claims in our history. What's happening in Canada? Is that going to change?
Well, we've seen the pendulum swing a couple of times now. I like to say we're about 15 years behind the states when it comes to class actions. So right now we're still a relatively plaintiff-friendly jurisdiction. In the last year, we have seen some appellate decisions coming down that are more stringent with regards to the certification factors in Canada. But we don't have many of the tests that are available in the United States to enable us to defend certification. And typically, our appellate courts have given a great deal of weight to the initial court decisions. However, particularly in the area of pharmaceuticals, we have seen that the appellate courts are looking more critically at certification and making the decision that unless there is a plausible methodology with regards to establishing causation, there's no point in going forward with a class action. You would say, well, my God, that seems like a pretty basic thing, but up until the last year, that really wasn't something that was being litigated very seriously in Canada.
So at prior meetings of the network, we've had some of your partners talk about the fact that Canada might be a good selection for you to, for a forum to bring a class action forward. But now, given the changes in the states, what's your advice? You know, if you have a client that has the chance to bring an action to establish some momentum with claims in a case, would you say go to Canada or stay in the States?
Well, I think they're going to come to Canada, and I think they're going to come to British Columbia and Quebec in particular. I live in British Columbia, and our jurisdiction has, I think, now the lowest certification standard in North America, which is a boon to my practice and an embarrassment to me at the same time. Well, Scott, thank you very much.
Thanks, Jim.